Welcome to the deep dive. Today, we're opening up a really critical chapter in U.S. patent law. It's a 2008 Federal Circuit decision that, laid down some definitive markers for anyone trying to patent software.
Especially software from that chaotic early period of the internet.
Exactly. Our mission is to take you straight into the heart of Net MoneyIN, VeriSign. We're going to dissect how the court handled these incredibly complex issues of, well, claim structure and prior art.
Yeah, and if you're in this space, this case is your blueprint for understanding what absolutely must be included in a software patent to make it hold up in court.
So it's not just an interesting historical case, it has real teeth today.
Oh, absolutely. I mean, this case is, well, it's mandatory reading. It gives you this painful clarity on two key ways patentees often fail. First, how you can't just claim a function in software without describing the how. That's the indefiniteness part.
Right.
And second, it draws this beautiful sharp line between anticipation, which demands an identical copy, and the prior art and obviousness, which is more about combining things. It's a masterclass in technical innovation meeting. Very strict legal rules.
Okay, so let's set the stage. We're talking mid-1990s. Doing anything with a credit card online felt, well, a little bit terrifying and brand new. But before we get into the tech, let's get the mandatory legal details on the table.
Sure. So the whole thing started in the district court for the District of Arizona. The judge there was Rainer C. Collins. After that, it made its way up to the U.S. Court of Appeals for the Federal Circuit.
And that's where our decision comes from.
That's right. The case number is 2007-1565, and the final judgment was handed down on October 20, 2008.
And who was on the panel deciding this?
The panel was Circuit Judges Lynn, Clevenger, and Moore. Judge Lynn actually wrote the opinion for the court.
Okay, so on one side, we have the patent holder, Net MoneyIN, who was representing them.
Net Money, or NMI. They had William A. Birdwell, Timothy R. Volpert, who were from Davis Wright Tremaine LLP, and also Alan Field.
And who are they up against? The name VeriSign is in the title, but it sounds like it was a much bigger fight than that.
Oh, it was huge. They basically sued the entire infrastructure of early online payments. The defendants, the appellees, included VeriSign, INC, U-Processing Network, and a whole host of others. They were just collectively called VeriSign for simplicity.
And their legal team.
For VeriSign, you had J. Michael Jakes, Thomas W. Winland, and Scott A. Herbst. And for E-Processing Network, Corby R. Vowell. This is a real heavyweight battle, the patent owner versus the major industry players.
Given the stakes, I'm not surprised the result was complicated. The final ruling was affirm in part, reverse in part, and remand.
That's it, a classic mixed bag. The court upheld the lower court's decision to invalidate several key claims because they were indefinite.
Too vague.
Too vague. And they also agreed with the denial of NMI's last-minute attempt to change their lawsuit. But, and this is the really juicy part, the Federal Circuit reversed the finding that one specific claim, Claim 23, was invalid because of anticipation.
So Claim 23 got a new lease on life.
It did, and that reversal gives us one of the biggest legal takeaways of this whole deep dive.
All right, let's get into the technology. We're in early 1996 when NMI files their patent. What was the state of the world for online payments?
The world was terrified. The idea of typing your credit card number into a web page and sending it over the open internet was not something people were comfortable with. The core challenges were trust and liability.
How do you make the customer feel safe, and how do you protect the merchant?
Exactly. How do you protect the merchant from massive liability and the need for, super specialized banking infrastructure that was just starting to exist?
This brings us to the prior art, the technology that already existed, specifically something called the IKP reference. What was the Internet Keyed Payments Protocol?
So IKP was a huge deal. It was published in 1995, co-authored by IBM and some other big names. The whole point was to try and standardize secure electronic payments. It's a foundational document.
And it laid out a system with 4 key players, right?
Right, the traditional 4.
Yeah.
You've got the customer, the merchant's bank, the acquirer, and the bank that issued the card.
And IKP had 2 different ways of doing a transaction, 2 protocols. We need to get specific here because the whole case kind of hinges on the differences.
Okay, so Protocol 1. This was basically the online version of handing your card to a cashier. The customer sent their confidential data, like their card number, straight to the merchant.
An unknown merchant, potentially.
A totally unknown merchant on the other side of the world. The merchant then takes that info and starts the authorization process with their bank. And here's the key part. The bank only tells the merchant if the transaction is approved. The customer is completely in the dark, just trusting the merchant.
So you're just hoping that this anonymous website is telling you the truth and not, storing your card number. That's a huge trust hurdle.
A massive one. So Protocol 2 tried to fix that. It changed the flow. In Protocol 2, the customer sends their card details and the authorization request directly to the merchant's bank, bypassing the merchant.
Okay, that feels safer.
It is. The bank then gets the authorization and notifies the customer directly that it's approved. Then the customer takes that approval confirmation and sends it back to the merchant to complete the sale.
So it shifts the trust away from the merchant and onto the bank, but it sounds clunky, a lot of back and forth.
It was complex, yeah. So now enter the inventor, Mark Ogram. And interestingly, he was a patent attorney himself. He looked at these 4 entity models like IKP and saw 2 big problems.
What were they?
First, that customer anxiety we talked about.
Yeah.
Sending your data to some unknown merchant. And second, the massive financial and security burden on the merchant. They had to get special certifications, handle all this risk. It was a huge barrier to entry for small businesses.
So what was his solution? What's the core of NMI's patents?
The solution was actually quite elegant. He just added a 5th entity.
A middleman.
A trusted middleman. The patents call it a payment processing or financial processing entity. This was a dedicated, secure intermediary. Its whole job was to handle the sensitive stuff.
How did that change the flow?
A customer sends their credit card information and the purchase amount directly to this 5th entity, not to the merchant. This processor then handles all the secure communication with the banks, gets the authorization, and, this is critical, it notifies both the customer and the merchant at the same time.
So it decouples the financial transaction from the product fulfillment. The merchant never even has to touch the credit card data. They just get a go or no-go signal.
You got it. It centralized the security. And that five-entity system, protected by two patents, the 737 and 917 patents, became the basis for the lawsuit NMI filed against VeriSign and everyone else back in 2001.
Okay, that sets the stage perfectly. So with that technology in mind, let's dive into the first reason most of NMI's claims got thrown out. Indefiniteness. This isn't about whether the idea was new, it's about whether they described it clearly enough.
Right. This is the battleground of patent law's clarity requirement. We're talking 35 U.S.C. Section 112, specifically paragraph 2, which demands definiteness,
Right.
and paragraph 6, which covers something called means plus function claiming.
And NMI walked right into that trap.
They did. Several of their most important claims, in both patents, were written in this functional style, which triggers a whole set of very, very strict rules.
Let's unpack that for a second. What exactly is means plus function claiming, and why is it so dangerous for software patents?
So Section 112, paragraph 6, it lets you describe part of your invention by what it does instead of what it is.
Yeah.
You can say, for example, a means for fastening.
Okay.
But, and this is a huge but, if you do that, the law says your claim only covers the specific structure you described in your patent specification for doing that function, and its equivalence.
So if my specification only shows a nail as the structure for my means for fastening, my claim only covers nails, not screws or glue or anything else.
Precisely. And if your specification fails to describe any structure at all,
Your claim is worthless.
it's indefinite under paragraph 2 and therefore invalid. You claim to function in the abstract without anchoring it to a real-world structure. And as NMI found out, when that structure is a computer, the rules get even stricter.
Let's look at the actual language that caused the problem. For Claim 1 of the 737 patent, the phrase was, a first bank computer including means for generating an authorization indicia.
Right. So NMI's first move was to try and argue that this wasn't even a means plus function claim to begin with.
How did they argue that?
Their argument was that the phrase first bank computer containing financial data already was the structure. They said any skilled person would know that a bank computer is capable of generating an authorization. So means for generating was just, a label for a known capability of that structure.
A very common argument. The structure is inherent, it's implied. But VeriSign shot that down. What was their counter?
VeriSign focused on the grammar, on the exact wording. The claim didn't say the bank computer generates. It said the bank computer includes the generating means.
So the means was a component inside the computer, not the computer itself.
Exactly. By phrasing it that way, NMI defined the means as a distinct subset of the computer. So the claim failed to state the structure of that specific subset, which pushed it right back into being a purely functional claim. The court completely agreed with VeriSign on that.
Okay, so the court affirms. This is a means plus function claim. Now we get to the second, more important question. Did the patent specification actually disclose the structure for that generating means?
And this is where the whole thing falls apart for them, and where we get this critical rule for software patents.
When you're dealing with a general-purpose computer, what does the law demand as the structure? Why isn't just saying a bank computer good enough?
The court leans heavily on a couple of key precedents here, Aristocrat Technologies and WMS Gaming. These cases establish that just saying a computer or a microprocessor is not enough structure. It's too ambiguous.
Why?
Because a general-purpose computer can perform a function in a million different ways. A bank computer could generate an authorization using, different programming languages, different encryption, different database lookups.
I see. It's like claiming a means for propulsion and just saying the structure is a vehicle. Well, is it a gas engine, an electric motor, a sail? You haven't defined the actual structure that does the work.
That's a perfect analogy. For a patent claim to be definite, the specification has to explain how you turn that general-purpose computer into a special-purpose computer that performs that specific function.
And how do you do that in the eyes of the law?
You have to disclose the algorithm. The algorithm, whether it's a flowchart, pseudocode, or just a clear step-by-step description of the logic, that is the corresponding structure for software.
So you can't just claim the end result. You have to disclose the specific recipe for achieving that result if you're going to use this functional claiming format.
Absolutely. Without the algorithm, the public has no idea what the boundaries of your patent are. You're effectively claiming every possible way to perform that function, which is illegal.
Which brings us to what you call the devastating concession. What happened during the oral argument?
It was brutal. NMI's own lawyer, when questioned by the judges, admitted, and I'm quoting here, there is nothing in the written description that expressly states what is going on inside that bank computer.
Wow.
Yeah. He basically conceded that there was no algorithm disclosed for the generating means.
And with those precedents like Aristocrat and WMS Gaming hanging in the air, that admission was the end of the line. No algorithm, no structure.
No algorithm, no structure.
Yeah.
The claims were purely functional, so the Federal Circuit had no choice but to affirm the district court's decision. Claims 1, 13, and 14 of the 737 patent were indefinite and therefore invalid.
The other patent, the 917 patent, had a similar claim that also failed, but for a slightly different reason related to claim construction.
That's right. This was about that new fifth entity, the financial processing computer. The function was about receiving data. The question was, from whom? The district court looked at the patent and decided on a very strict interpretation.
What was that interpretation?
The court said the financial processing computer had to receive the account data and amount data from both the customer computer and the merchant computer.
And NMI, of course, argued for a broader reading.
Of course, they wanted it to be read as data from the customer, the merchant, or both. But the Federal Circuit just shut that down.
On what grounds?
They said NMI was essentially trying to argue a brand new interpretation of their own claim for the first time on appeal, which you're not allowed to do. They were stuck with the strict construction they had litigated in the lower court.
Okay, so the strict construction stands. The computer has to get data from both sources. What was the consequence of that ruling?
The consequence was another concession. NMI admitted that under that strict construction, their patent specification didn't disclose an algorithm or structure to perform that very specific two-source function. So, boom, that claim was also invalid for being indefinite.
So in both cases, the functional claims died because they lacked corresponding structure, a really powerful lesson.
A very expensive lesson for NMI.
Let's shift gears. We've talked about indefiniteness, which is about clarity. Now let's talk about novelty, or anticipation. This is where NMI finally got a win, and where the court laid down some incredibly important law. We're focused now on Claim 23.
Yes, this is the good part for NMI. Claim 23 described their system in terms of 5 distinct communication links, the specific steps of information flowing between the customer, the merchant, the payment processor, and the credit card server.
And the question was, did that IKP document we discussed earlier already describe this exact 5-step process? Did it anticipate the invention?
Right. The district court said yes, it did. It found the claim was invalid under Section 102A. But the way it reached that conclusion was flawed.
What was the district court's error? How did it combine things?
So this is the key. The IKP reference, as one single document, did contain all 5 of the communication links from Claim 23. But, and this is everything, they weren't all in one place. Some links were in IKP's Protocol 1, and the others were in Protocol 2.
So the district court just picked and chose from the 2 different protocols and stitched them together to match the claim.
That is exactly what it did. The judge concluded that a simple combination would produce the system. And NMI's whole argument on appeal was, you can't do that. That's not anticipation.
VeriSign's counter-argument must have been that if it's all in the same document, it should count.
It was. They argued that if all the elements are within the 4 corners of a single document, that's good enough. But the Federal Circuit used this as an opportunity to really draw a hard line.
So what is the absolute, non-negotiable standard for anticipation?
The standard is identity. Pure and simple. The prior art has to disclose the entire invention, and not just all the elements, but, and this is the magic phrase, it has to disclose them arranged or combined in the same way as in the claim.
It's not just having the ingredients, it's having the exact same recipe with the steps in the exact same order.
Perfect analogy. If the prior art has all the parts but connects them differently or they function in a different order, it's not anticipation. The test is not whether a skilled person could have combined the pieces from the reference to make the invention.
Why is that could have combined thinking so dangerous for an anticipation analysis?
Because that's the test for a completely different part of patent law. Obviousness under Section 103. The Federal Circuit basically scolded the district court for using an obviousness standard, this simple combination idea, to decide a novelty question.
So the difference, however small, pushes it out of anticipation and into the realm of obviousness.
However slight. That's the rule. The second you have to start picking, choosing, and combining different parts of a reference that the reference itself didn't explicitly link together, you're no longer talking about anticipation.
The court must have used some strong precedents to back this up.
Oh, they brought out the big guns. First, they cited a 1984 case, Lindemann. It was about a big hydraulic scrap metal shear. The prior art had all the mechanical parts, but the court said it wasn't anticipation.
Why not?
Because the part-to-part relationships were different. The prior art machine was put together in a way that made it operate completely differently. The arrangement was wrong.
Okay, so the ingredients were there, but the recipe was for a different dish entirely.
Exactly. Then they brought up a 2000 case, a Cullicum. This one is a crystal clear example. The invention was a method for taking oxygen out of water. The district court found anticipation by combining a picture from the prior art reference with a separate paragraph of text from the same reference.
What did the picture and the text show?
The picture showed a certain chemical, hydrogen, being used with a specific piece of equipment. And a totally separate paragraph talked about using a different chemical, hydrazine, for the same general purpose. The court just Frankensteined them together.
And the Federal Circuit said you can't do that.
They said no. There was no link in the document suggesting that you should use hydrazine with that specific equipment from the picture. The judge had to be the one to make that connection, which means the reference itself didn't disclose the invention arranged as in the claim.
That's a huge protection for inventors. The prior art has to hand you the invention on a silver platter. It can't just give you a box of parts.
That is the perfect way to put it. So applying that strict standard back to NMI's case, what was the final holding on Claim 23?
Well, the IKP reference had the 5 links spread across 2 separate protocols. Neither protocol by itself had all 5 links arranged in the way Claim 23 required.
So as a matter of law, it could not anticipate the claim. The Federal Circuit reversed the summary judgment of invalidity. It was a huge win for NMI on that specific claim.
All right, there's one last piece to this puzzle. It's a procedural issue, but an important one. The court had to decide if the district court made a mistake when it refused to let NMI add an old claim back into its lawsuit.
Right, this is about the claim for inducement of infringement. It's a look at the rules of the game. So early in the lawsuit, NMI had accused the defendants of inducing infringement. But then, in 2003, in their third amended complaint, they expressly abandoned that claim.
They took it off the table themselves.
Publicly. They said they had elected not to assert it. So for VeriSign, the goal was to make sure that claim stayed dead and buried.
And what did VeriSign do to ensure that?
Well, almost 2 years later, in 2005, VeriSign filed a motion for summary judgment on that very issue. They asked the court to formally rule that NMI had waived its right to ever bring that claim up again.
And NMI's response was to try and bring it up again.
Immediately. They filed a motion to submit a fourth amended complaint to re-add the inducement claim they had just abandoned.
What was their legal argument for being allowed to do that?
It was clever. They used Rule 15b of the Federal Rules of Civil Procedure. They argue that because VeriSign filed a motion about inducement, VeriSign had given implied consent to litigate the issue. And if there's consent, amendment should be mandatory.
A sort of, you brought it up, so now it's fair game argument.
Exactly. But VeriSign's counter was all about intent. They said, hold on. We weren't asking the court to decide if we actually induced infringement. We were asking the court to rule that you waived your right to even ask that question.
So it was a procedural motion, not a substantive one.
That's what VeriSign argued, and the Federal Circuit agreed. They said VeriSign's motion was a defensive move to lock the door on that claim, not an invitation to reopen the debate. So, no consent.
And without that consent, the decision to allow the amendment or not was up to the judge's discretion.
Right. And the court looked at the timing and said, absolutely not. NMI was asking for their fourth amendment, 20 months after the deadline for amendments had passed, and 4 months after discovery had closed.
That would have been a nightmare. It would have meant reopening the whole case.
It would have caused extreme delay and severe prejudice to VeriSign. They had built their entire defense for years based on the fact that inducement was not part of the case. So the Federal Circuit said the judge was well within his rights to deny the motion. That denial was affirmed.
Okay, so let's pull all these threads together. We've seen functional claims fall, a novelty claim get revived, and a procedural gamble fail. What was the final scorecard?
The final judgment was this. The Federal Circuit affirmed the invalidity of all the means plus function claims in both patents because they were indefinite.
No algorithm.
No algorithm. They also affirmed the denial of the motion to amend. NMI could not bring back its inducement claim. And, most importantly, they reversed the summary judgment on Claim 23, finding it was not anticipated by the IKP reference. That claim survived to fight another day.
And was there any disagreement among the three judges on the panel about any of this?
No. Based on the record, Judge Lynn's opinion was unanimous. No dissenting opinion, no separate concurring opinion. They presented a completely unified front.
So for the people listening, what is the lasting legal significance of this case? Let's start with the indefiniteness part.
The ruling is incredibly powerful and clear guidance for anyone drafting a software patent. It basically says if you use means plus function language for a computer-implemented invention, you cannot be vague. You can't just name a component like a bank computer. You must disclose the corresponding algorithm.
The step-by-step logic.
The logic, the flowchart, the recipe. If you don't, your patent is vulnerable. And this decision is still cited all the time to kill patents that are too high-level and functional.
That's the shtick. What about the carrot? The big win for patentees on anticipation.
This is probably the decision's most important legacy. It provides a definitive clarification on the difference between anticipation under Section 102 and obviousness under Section 103. It forces courts to recognize that an anticipating reference has to be a complete, fully formed blueprint of the invention.
With everything arranged as in the claim.
That exact phrase. It stops courts and defendants from doing what the district court did here, playing with Legos. You can't just pick a piece from page 1, a piece from a diagram on page 10, and snap them together to say you've anticipated the claim.
If you have to do any assembly yourself, it's not anticipation.
If the person skilled in the art has to use their judgment, pick and choose, or rearrange things, then the argument isn't about novelty anymore. It's about obviousness, which is a much higher bar for an infringer to clear.
So if you're walking away from this deep dive with just one thing to remember, what should it be?
The single most important takeaway is this. Anticipation requires identity, not assembly. You cannot build an anticipation argument by combining separate and distinct teachings, even if they're in the same document. If the prior art doesn't hand you the complete invention, fully assembled and arranged in the same way as the claim, the argument isn't anticipation, it's obviousness. And that distinction protects inventors from having their novel combinations dismissed too easily.
Identity versus assembly. That's a powerful and clear way to put it. It really underscores that the law demands total fidelity to the specific claimed invention. This was a fantastic breakdown of a really foundational case. Thank you.
My pleasure. It was fun.
And thank you for joining us for the deep dive. We'll see you next time.